was for speeding 54 in a 40-mile-an-hour zone with expired vehicle license plates.
Officer Hogue, badge number 130. What facts or information are you alleging gave you probable cause to stop?
Okay, we're not going to go to trial here, sir. I need your license. You need to identify yourself for the license, registration, and proof of insurance.
I'm building a record for the court.
Okay, I'm asking for your license, registration, and proof of insurance.
What facts or
I'm
information?
going to ask you one more time, and then we're going to get out of the car.
Well, I'm not getting out of the car.
Okay, well, if I place you under arrest...
Tell him. You tell him like it is. You ain't getting out of the car. You sure right. I'm not getting out of the car. You're not going to tell me I got to get up. You ain't going to make me get out of the car. There's nothing you can do. There ain't no crime. You're going to have to stop that. Look at him trying to get violent already. This dude already trying to get violent a little bit. Watch.
Welcome back, everybody. As many of you guys know, I'm a law enforcement trainer and instructor. I train and instruct military and law enforcement all over the country on various law enforcement disciplines to include constitutional law, case law, patrol tactics, use of force, advanced investigations, etc. And today we're going to be talking about people that don't like to listen to law enforcement on traffic stops. And so I'm always and as you guys know from this channel, I'm very critical of law enforcement, especially when it comes to law enforcement officers not understanding the basics. But that also goes both ways. There are a lot of citizens that don't know the law either. There's a lot of citizens that don't actually understand the various concepts and doctrines out there, especially as they relate to law enforcement contact, right? So we're going to kind of break this down, and there's a lot of people out there, and a lot of them are sovereign citizens, but there's a lot of people out there that think that they know what the law is, and really you'd be surprised how much authority law enforcement has on a traffic stop. In fact, I don't even think most law enforcement understand the actual authority they have on a traffic stop. And so, the ability to articulate this is going to become important. And if you do want to get good at being law enforcement, you do want to get good at community policing and, just being a rank and file patrol officer, understanding these concepts would greatly help you. So let's just talk about the case law. Let's just jump into it. So the requirements for stopping somebody and demanding identification, for example, you can see we have on the screen here, Brown v. Texas, 1979. We talk about this case law frequently, which rightfully we should. So again, the Supreme Court has affirmed that law enforcement needs reasonable articulable suspicion in order to detain, compel somebody to identify themselves. Okay, so that's pretty standard. And then we look at traffic stops. Reasonable articulable suspicion is also the requirement for conducting a traffic stop. So a lot of people think that you need probable cause to conduct a traffic stop and to ask for identification, and that is not the case. You only need reasonable articulable suspicion, and that is affirmed by the case law. Everything from the United States court case precedents of United States v. Cortez to here in the state of Oklahoma, State versus Bernanzi, 2022. So again, everything from state Supreme Court to the United States Supreme Court has affirmed this numerous times, numerous circuits, and you can see those here. And so that is important because this traffic stop was made for speed, and so speed and registration. So it appears that the officer has probable cause to conduct the traffic stop, even though all he needs is reasonable suspicion. And so the question that a lot of people get is, well, can you actually stop somebody for speeding, right? Well, speed is a infraction, so let's just kind of flesh this out because some people need it explained to them, and that's fine. So we're gonna go from state level all the way to the Supreme Court. Okay, so here you can see the state of Oklahoma. For example, state statute, it's going to be Title 47, so 47 OK 11-801E as in Edward or Echo or however you want to say E, right? And so this would be the statute for speed here in the state of Oklahoma. That would be one statute, and so there you go. So Oklahoma statute says you can't speed, and every state has its own statute as it regards to speed. Now, if we then go and do a deeper dive into it, we can look at the Supreme Court case precedences. As you can see here, everything from United States versus Nunez to U.S. versus Colden, U.S. versus Fuentes, United States versus Riley, United States versus Wren, right? And so multiple courts, Supreme Court cases as well. So multiple Supreme Court cases have affirmed that an officer's estimate that a vehicle is traveling in slight excess of the legal speed limit, when supported by radar, pacing methods, or other indica of reliability, can establish, in the totality of circumstances, the reasonableness of the officer's visual speed estimate, can provide the officer with reasonable suspicion or probable cause to conduct a traffic stop. So again, even the Supreme Court states that if an officer is able to, based upon the totality of circumstances, ascertain that there is an excess of speed, again, whether it's through pacing, radar, whatever implements that he uses that are verifiable in the totality of circumstances, he can absolutely conduct a traffic stop based upon those elements. Again, numerous Supreme Court case precedences affirm this. So when it comes to the speed, clearly, a traffic stop can be initiated when reasonable suspicion exists. I mean, that's just, it is what it is, guys. I don't know. The fact that this is even controversial is mind-numbing, but absolutely can be done. Now, the next thing we have is a registration issue. All right, so let's look at the Supreme Court case precedences into that. Again, the United States Supreme Court affirmed that states can require vehicle registration and licensing fees, finding it a reasonable exercise of state power to regulate highways and ensure public safety. That's Hendricks versus Maryland, 1915. Again, Hendricks versus Maryland, 1915. And then furthermore, another Supreme Court case precedence, California versus Buzzard, 1966. The United States Supreme Court upheld the right of states to require registration and licensing for non-resident servicemen stationed in the state, even if they maintain a residence elsewhere. And so in this case, the Supreme Court even affirmed that even a service member that is a non-resident in which he is currently stationed still is required to have their vehicle licensed and registered. So again, even when we look at possible military exemptions, the Supreme Court has again put their foot down and say, no, this is entirely within the realm of reasonable. And so also, well, how did the officer know that the tag was in fact expired? Well, there's a couple ways. A lot of states just use color codes. Color is easy, so they have stickers on their vehicles and on their tags, and that will indicate the month and year in which that tag expires. Also, law enforcement have things called CADs, computer aided dispatch, so they have computer systems where they can query this. And so I know a lot of people ask, well, don't they need reasonable suspicion to do that? No, actually they don't. And that was established in Kansas v. Glover, 2020. United States Supreme Court affirmed that when a police officer lacks information negating an inference that the owner is driving a vehicle, an investigative traffic stop made after running a vehicle's license plate and learning that the registered owner's license has been revoked is reasonable under the Fourth Amendment. So again, if a police officer is running tags and he runs a tag and that tag states that it is expired, he's well within his rights to conduct a traffic stop. Also, if he runs the tag, and let's say the tag's not expired, but the registerer, so the person who the vehicle is registered to, for example, has a expired license or suspended license. In this case, that would also give the officer reasonable suspicion or probable cause to stop that vehicle and conduct a traffic stop independent of anything else. And so, again, over and over and over again, this has been absolutely affirmed. And so the question is, well, what happens if they refuse to give their license over? Well, again, as you can see here, Pennsylvania versus Mims, right? The officer is 100% within his rights to assist that person out of their vehicle. And so a lot of people, again, they may not like that. They may not think that is reasonable, but it's constitutional. Again, just the court has held that an officer that has made a lawful traffic stop may order the driver out, may order the vehicle, may order the driver out of the vehicle, and they may conduct a pat-down search if they reasonably believe the individual is armed and dangerous. And so, again, they could absolutely at any time, just because they conducted a lawful traffic stop, order that gentleman out. And so, again, what happens, and I guess the real question of it is, what happens if he just refuses? And that's how, in my honest opinion, that's how law enforcement should train. Law enforcement should train to that standard. They should train to the standard of, okay, I'm doing everything within case law precedents is affirmed by the United States Supreme Court, affirmed by our state appellate court, our state Supreme Court, affirmed by statute. So everything I'm doing from the municipal level, state level, all the way to the United States Supreme Court level is 100% affirmed and is guided by case law precedents. What happens if somebody just says, no, officer, I'm not doing that? Well, that's where we have statutes like obstruction, and that's where we have the case law that says no, an officer has every right to conduct these searches or conduct these queries or conduct, whatever it is they're trying to do based upon the doctrine. And so, again, if we look at for example, the state of Oklahoma, if we look at the obstruction statute, this is the jury instruction pursuant to Oklahoma State Constitution here, and Oklahoma Supreme Court case precedences, and that would be found for Oklahoma. For Oklahoma, that would be Trent v. State and Ratcliffe versus State of Oklahoma. That's found, again, Oklahoma Jury Instruction CR 6-48, obstructing officer and their performance. No person may be convicted of obstruction of an officer in the performance of his or her duties unless the state has proved beyond a reasonable doubt that each of these elements have occurred. First, willfully. So he's asking for the license and the person willfully says no. Willfully does not give over his license. Well, you have willfully. Second, delay or obstructed. In this case, he's absolutely delaying it. But, again, the officer has no problem, I think, in this predicament here to state that he's delaying or obstructing the officer's ability. Third, is a police officer, right? Fourth, known to defend to be a police officer. Yep. The defendant himself said, "You're officer and what's your badge number?" And I think that's great when citizens do that, because, again, a lot of times citizens don't know the law, right? So if the first thing a citizen does is, "Officer, I want your badge number," and they're recording, I'm recording, right? I think that's great. Yeah, absolutely, I'll give you my badge number. I'm all about giving badge numbers, and I'm all about identifying myself because, again, I know based upon state Supreme Court case precedences, again, Trent v. Oklahoma and Ratcliffe versus Oklahoma, I know the obstruction statute intimately. I know that the third and fourth elements, so 2 of the 4 elements, are just establishing the venue of me being a law enforcement officer. Isn't that wild? And so, yes, a police officer, I am known to defend to be a police officer. I am, and I was, because they even repeated back. This guy just the fact that he repeated back to me, okay, so you're officer so-and-so, badge number so-and-so, he's already completed 2 of the 4 elements necessary, or 2 of the 5 elements necessary for me to prove the obstruction violation. I mean, thank you. Thank you, good, kind person. And then 5th, in the discharge of any duty of his or her office. And so I think we've clearly established the discharge and duty of the office with the case law precedents, as aforementioned. It's 100% there. And so, again, the obstruction is really, once you actually understand, the jury instructions, you actually understand the elements for various statutes, your job becomes way easier. Again, just by that person demanding your badge number, you have affirmed 2 of the 5. They have done 2 of the 5 for you. And so the other thing you need is just for them to say no, right? That's what I'm not coming out of the car and I'm not giving you my ID. Perfect. You've done it for me. You've 100%, just by saying no, so think about it. They have established it. Look at obstruction. Again, it's right here on the screen. By them asking you for your shield number or badge number, they've gotten 2 of the elements knocked out immediately. Boom. 2 of the elements done. Then if they say no, first element and second element, so 2 more elements done. right? So those elements are already completed. And so if your request was in the discharge of your duty, of your office, boom, obstruction complete. They've completed it for you. That's how easy obstruction is. And again, this is pursuant to case law. And so, again, this guy could not make this obstruction charge any easier. But again, people that like to be street lawyers, they don't know what they don't know. And unfortunately for cops, they don't know what they don't know either. So there you have it. I hope this video was helpful for you guys. Again, this should be taught in every academy. This is the basics this is literally building block number 1 of law enforcement contacts with citizens. And again, the fact that most officers do not even know the case law precedents, as I've displayed them out here to you, the fact that they don't know this just shows that we have a big lack, a big problem in our training infrastructure as it regards to law enforcement. Again, if you don't understand these concepts, my honest opinion, and again, this is just my opinion, this is not indicative of any police organization out there, this is just my held opinion, you shouldn't be on the road. You should absolutely not be on the road. You shouldn't be allowed to be on the road. And the fact that FTOs don't talk about this, the fact that you have field training officers that don't even know this case law exists, the fact that this is not even gone over at police academies is absolutely ridiculous. It's reckless. It's reckless at the least, in my humble opinion. So there you have it. I hope this video was helpful for you guys. If you have any questions, please leave them in the comment section below. And most importantly, tell me what you think. Do you think this driver of this vehicle actually understands what it is he's doing? What do you think? Why do you think that he's acting in this way? Tell me what your guys' opinions on sovereign citizens are. Really curious to hear your guys' thought in the comment section below. As always, guys, long live the Republic.